after my deputy director approved the drafting and the contents. So it should have come from the prosecutors.
And that document, is it part of the legislation that there must be the 28.2A, or is it something that's a practice or procedure in the SOP? Where does it come from, and why do you need it?
Sometimes Advocate Johnson would ask for it, sometimes not. But with the 27 referral, she would. In terms of the Act, Advocate Johnson needs to delegate authority to prosecutors, either deputy director, senior state advocates, to prosecute on behalf of the investigating director. And that is the purpose of a 28.2, to provide us with a certificate to authorize us. It's the same thing as a delegation. So if I was a district court prosecutor and they gave me an acting stint in the regional court, the DDPP of that jurisdiction would issue a certificate of delegation to allow me to prosecute in the regional court. So it's a delegation for us to have permission to, or authorization to prosecute.
We're going to include it in
Within IDEC, is this done once off, or is it done per matter?
Like I said, Advocate Johnson, because of the 227 referrals, the first one I knew that I was requested to do one. And so it was the deputy director and I were trying to figure out how to format it and how it was supposed to be worded because we didn't have an example. But it became a standard procedure later on. But like I said, standard procedures were deviated very often according to what Advocate Johnson wanted at the time.
What I'm trying to understand is the delegation to prosecute. Would that not be done once off? Because, for that to be a delegation each time a matter comes up, it sounds quite cumbersome. So would it be a once-off delegation? Or?
We are issued with a delegation. I think we've been issued with 3 different ones now. With Advocate Johnson, it's a certificate that we generally carry with us just in case either a judge or a magistrate wants to see. But that is done, if memory serves, it's done in terms of Section 24 of the NPA Act, not in terms of Section 28.
Can I just clarify? And it may be a difference of practice and what the law prescribes. A quick look at 28.2 is authority to investigate, not to prosecute. Were you using it differently?
Trying to find my NPA Act. In our exhibit file, do we have the 28.2?
It was there at some point, I'm not sure. NPA Act?
Have you found it? I see you are paging. Have you found the Act?
Section 20.
No.
Can we display it in front of you? You should be able to see it on the screen in front of you. Display.
And whilst you are looking, in any event with regard to a delegation to prosecute, as I understand it, you and other prosecutors are part of the NPA anyway. So it would make much sense for there to be a new delegation to prosecute, as it were, if you already have a delegation to prosecute. But please respond directly to the question by Commissioner Baloyi.
Correct. It is to investigate.
Thank you.
Okay. We'll include the email chain regarding the 28-2As in the bundle. For now, we'll just display it. It's an email from Ms. Latwayo on the 12th of November 2025 to Mr. Tlale, copying you, where she's responding to his July email where he says, these are the soft copies for your authorizations. She sends an email to him saying, good morning, Tsepo. I have just realized that Brapita is not designated in these matters, more especially leg 2, and currently is the one who is appearing in court. May you kindly add him? And his response is above that. He says, he is, please receive attached. And what he attaches, if you look at the third page, is the section 28-2A designations, 8 August, you'll see the date is 8 August 2025.
Correct.
And we do have the attachments. The first one, you'll see once it comes up, it again refers to, in the first line, whereas I, Andrea Johnson, the Investigating Director, on 30 May 2025, have decided to conduct an investigation in terms of Section 28(1)A. Again, there's reference to the authorization, which you know nothing of, for 30 May 2025.
Correct.
And was November 2025 the first time that you saw this 28(2)A?
Yes, it was the first time that it was emailed to us.
If you look at the third page, it's got the signature date of Advocate Johnson. It's 8 August 2025.
Correct.
Okay. And insofar as the 28(1)A authorization, so we've spoken about the application for authorization. Have you seen this signed, other than the 30 May 2025, that's part of the bundle that was displayed during Advocate Johnson's evidence? Have you seen an authorization for the Mokwele matter, other than the 30 May 2025 one?
I saw the one that I sent that wasn't signed on the 3rd of June. And then these, but a signed one from Advocate Johnson was never submitted to us.
28(1).
Correct.
Okay. Only the 30 May 2025 one that was displayed here at the Commission. Now, then if we can move on to another topic insofar as the Mokwele matter is concerned, and this relates to the evidence of Advocate Serunia regarding the bail amendment and bail application, bail appeal proceedings from September 2025.
Correct.
Now, his evidence, insofar as we know that you were involved somewhat in that process, but you were no longer the prosecutor on the Mokwele matter, or were you still with Ms. Latwayo?
No, on the 8th of August, Advocate Johnson had separated us completely on the matters. However, with regards to the bail application, I was asked by Advocate Serunia to assist.
Okay, and just to recap that Advocate Serunia gets involved in August.
Correct, on the 8th of August.
Well,
yes.
he was at the first appearance in June, but then his real involvement starts in August 2025. He then sends his trial preparation memo where he raises pertinent questions regarding the case. And your evidence was that when he got involved, there was a voice that you could now go and speak to, somebody that would hear the complaints about what your assessment, you and Ms. Latwayo, your assessment of the matters are concerned.
Correct.
And he seemed to hold the same views.
Yes.
We know that Mr. Perumal responded to his email, but you didn't respond to his email where he had raised all those questions. And you were copied in that email, you and Ms. Latwayo. Can you tell us why you didn't respond?
If the Commissioner and Chair would note the times of Mr. Advocate Serunia's emails, it was generally towards the latter part of the afternoon or evening. During the day, Advocate Latwayo and myself would sit with Advocate Serunia in his office, and we would dissect all of these things, and we would voice our concerns, and he even testified to the effect that they were not listening, the investigators were not listening to Advocate Schlatzwey and I. So that is why when I testified on the 29th of July, I said when Advocate Serunia started listening to us and taking these things up in writing and asking for answers, it gave us a sense of relief. With regards to the bail question, I was assisting due to Advocate Serunia's health, so we needed all hands on deck. But there are messages with regards to how that transpired.
Yes, we'll get to those messages. I think